The next case is Kyle Burgett versus SP Orville LLC, doing business as Serpentina Chevrolet Buick of Orville. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument if that applies here. You can refer to them by initials or terms like the child. We have read your briefs and are prepared to proceed when you are.
Good afternoon. May it please the court. Emily Engowitz on behalf of the appellant Serpentini, and I'd like to reserve 3 minutes for rebuttal, please. Your Honors, this appeal arises from a consumer sales dispute regarding the sale of a used vehicle. The vehicle was sold for just under $25,000. There was front rail damage, which Serpentini did not know about at the time of the sale. There's evidence from multiple sources that it cost under $1,000 to repair the vehicle, and yet this resulted in a $121,000 judgment against my client. This court should reverse the decision of the trial court and rule in our favor for 3 primary reasons. First, there's insufficient evidence presented at trial to support the trial court's liability determinations as to all 3 of Mr. Burgett's claims. Second, the trial court's decision to award diminution in value damages instead of the cost of repair was illogical and erroneous, and the court compounded this error by trebling damages, given that Mr. Burgett failed to introduce any evidence at trial to support treble damages.
Wasn't treble damages just part of the statute?
Treble damages, so it's a mixed question of fact and law. So there has to be sufficient evidence of decisions that are on point, certified decisions, and that's an evidentiary issue. And there was no evidence admitted of that at trial. It was simply attached to the written closing argument. Whether or not those decisions...
Is it something, let's say this was to a jury, would that normally go to a jury, these evidence of the case law or the statute that says it's a violation?
Your Honor, I believe there still has to be evidence presented during trial, and then it's a legal determination, I believe by the trial court, as to whether those specific decisions presented actually are even relevant to the case.
They presented this in their closing argument brief, in my understanding from the record.
Correct, so they rested their case and they did not...
And after that, when the closing argument briefs were filed, did you have an opportunity to object to this process at the trial court?
No, there was no opportunity to object because the court ordered that closing argument briefs be submitted simultaneously, so Serpentini did not get an opportunity to respond. The plaintiff did get a rebuttal.
Did you argue at that point in time that they had not submitted any evidence of treble damages at the trial? And I don't know if you were trial counsel, so I apologize.
No, I was not trial counsel, but...
Does the record show that when the closing argument brief was filed, that below they said, hey, look, there was error here because they did not submit their evidence of treble damages during the trial?
No, there's no opportunity to object, so it was just, if they were written closing
Well, you could make the
statements-
argument. You could at the end of the argument say you can't apply treble damages to the trial court because they didn't submit any evidence during trial.
I think that the closing argument briefs definitely objected to treble damages, that's certain.
And because there was no evidence submitted during the trial.
Correct, it was erroneous, correct. So that's with respect to damages. And then the attorney fee award was also erroneous because the court found Serpentini did not know about the structural damage, and it has to be a knowing violation in order to support attorney fees under the CSPA. And then finally, with respect to attorney fees, the trial court granted Burgett's attorney fee motion without allowing Serpentini the opportunity to respond. That violated Serpentini's due process rights, and that it was not afforded the opportunity to be heard. So those are the 3 assignments of error, and I can get into each one a little bit more detail. Beginning with liability, there's the Magnuson-Moss Warranty Act claim. And that claim...
And the Consumer Sales Practice Act claim, or was it just a claim under the MMWA?
There's MMWA and CSPA. So
okay,
there's
so 2 claims.
Yeah, so turning to the MMWA claim first. It's a prerequisite for recovery for breach of warranty that the buyer must afford the warrantor a reasonable opportunity to repair. That did not occur in this case. There's no evidence that Mr. Burgett made a warranty claim, requested that Serpentini repair it.
They sent a letter at some point saying the car has these problems to your client.
The letter was insufficient because it was sent a year after the fact.
Well, they sent it.
They did send a letter, you're correct. The letter itself was insufficient to afford Serpentini the opportunity to repair, because it merely asked for rescission of the agreement. They wanted to give the car back. It did not request repair. And so for that reason, that was not.
Maybe your client responded in some capacity to them that they did not request that, or what?
I don't believe there's evidence of a response. I think that Mr. Burgett just went ahead and filed a lawsuit.
So under the MMWA, parties could ignore letters sent to them and then say we didn't give them the chance to repair that.
No, that's not what we're arguing. The point is that there was never an opportunity because there was never a request to repair.
Your client never asked if we repair the vehicle.
There was never a demand made for repair. There was just the rescission, and there wasn't any more detail provided in the letter. So our position is that, it's mandatory under Ohio and federal law that there's an opportunity to repair, and that just wasn't presented in this case. So that's our argument with respect to liability of the MMWA. Turning to the CSPA claim, there's insufficient evidence of this. First of all, the trial court expressly found that Serpentini did not know about the structural damage. And so the whole basis of this alleged misrepresentation has to do with the vehicle's quality. So how could they have misrepresented something they didn't know?
I thought the misrepresentation was from the trial court's perspective that your client said we inspected and they didn't inspect.
The inspection and the certification, and I think that was part of where the trial court went astray, was that this really had to do with a Q-certified warranty. So the certification was in conjunction with a warranty, and the warranty was to repair the vehicle. Moreover, Mr. Burgett testified that he knew this inspection and certification was only mechanical. And there was a lot of mechanical, there was an inspection done, there were a lot of mechanical issues that were corrected.
I thought there was no evidence of the inspection, from what I could gather from what the brief were telling me,
that your client couldn't produce the documents that said, here is our inspection that we did before we sold this car, we checked everything. That doesn't exist.
I believe there's no evidence of a specific checklist in the record, but if you look at plaintiffs or trial exhibit 19 and 20, they're the service records, which indicates that a used car inspection took place. And again, this was a mechanical inspection. There were multiple things fixed, from the radiator, the coolant, I believe oil change. It's multiple pages of things were inspected and fixed. And again, Mr. Burgett, there's just no evidence that this related to the body of the vehicle. And again, trial court expressly found that Serpentini didn't know about the structural issue.
So there was nothing noted about the damage to the body of the vehicle or the certification that they made, and this Q certification / warranty did not include the body of the...
Correct, it did not include the body, and then there was a Carfax report, and that was the only information that Serpentini had when it purchased the car at auction from Mannheim, was this Carfax report, which indicated that it was involved in a prior accident where there was front end damage. So that information was all that Serpentini had. That was passed on to Mr. Burgett. Mr. Burgett signed the buyer's guide in this case, that's trial exhibit 4, and that warned him that frame, body, structural issues, those sorts of defects can occur in used cars. He testified that he recognized that this was designed to put him on notice of those things. And again, this certification, there's no evidence that it was meant to cover any kind of body issues. Plus the trial court found that Serpentini just didn't know about any of these structural issues. So for these reasons, there's insufficient evidence supporting the CSPA claim. Similarly, with respect to fraud, again, back to the fact that the trial court found there was no knowledge. This completely destroys their fraud claim, because how could there be a fraud claim if Serpentini did not know about the damage? So there's insufficient evidence of that as well. Turning to damages.
They made a claim that there was a front camera on this, and there was putting a front camera. Isn't that fraud?
The front camera issue, so that's really a non-issue for appeal, because there was no damages, there was no evidence of damages as to relating to the front camera presented. Plaintiff's expert provided a diminution in value opinion, and that was not included in that. That just purely included the structural issues to the car, as well as some cosmetic issues which were pre-existing.
And the front camera never was, they attempted to repair it, but they never made it work on the vehicle. Is that fair?
I don't know that that's fair. I believe that it was brought in multiple times, and the Serpentini's records demonstrate that as of the last time it was brought in, it was repaired, and so that documentary evidence shows that it was in fact
repaired. And
repaired.
never brought back to them to say this isn't working, and they did not repair at that point.
Correct, I believe that's the case, it was not brought back. But again, if there's no evidence of damages, that claim ultimately fails, because there was no evidence presented by plaintiff showing what damages that caused. It just wasn't included in the expert's valuation. But moving on to the diminution in value damages themselves, those were erroneous for a number of reasons. Purpose of damages awards under the CSPA is to make a consumer whole. Right, and so, but there's evidence from multiple sources that the vehicle could have been fixed for less than $1,000. So here you have diminution in value for $14,000.
I understand the appellees would be saying these are expectation damages, which is just different between what you thought you were getting and you were actually getting, and not what they were asking for, and that's permissible under the CSPA.
We're not arguing that that's not a permissible measure of damages. We're saying that in this case, it was illogical and unreasonable given the stark difference between this $1,000 that could have been.
That $1,000 was from one of your client's employees.
It was from that, and also there was
a detailed list of what the estimate was to get to $1,000.
I don't believe so. Our witness did not, but there was a estimate from the body shop where Mr. Burgett took it after the second accident, and that indicated that it was approximately $700 to fix this front rail issue. And so our argument is really just this huge disparity between those two numbers makes it unreasonable and illogical.
Wouldn't that be something for the trial court to decide as a matter of credibility, in essence? Wouldn't that be your standard review here?
I think a review is abuse of discretion, and our position is it was an abuse of discretion given the disparity in those numbers. And further, the plaintiff's expert, he expressly found in his report that the vehicle shouldn't have been sold, quote, without repairs being done to restore it. So that should have been the proper measure of damages and not diminution. Treble damages, I think we spoke about that a little bit, and I don't want to cut too much into my rebuttal time. But again, that's an evidentiary burden that they didn't meet, so that was inappropriate for the court to treble damages. Attorney fees, again, they only be awarded where it's the supplier knowingly commits the violation. The trial court expressly found the opposite. And then finally, no opportunity to be heard on attorney fees. So that's clear error. There was no reason to file a 60B. This was a final appealable order, and this is the appropriate way to challenge it. So we'd ask this court to reverse the judgment of the trial court, enter judgment in favor of Serpentini and all claims. If there's no questions, I'll reserve the remainder of my time. Thank you.
Kit, that screen went out. Kit? Plus the screen. Is it?
Good afternoon, Your Honors. Christina Gill-Roseman. I am here representing Kyle Burgett, appellate. So I want to start talking about the Ohio public inspection cases issue. As stated in the brief, the public inspection files and certifications need to be presented to the court, but there's no requirement for admission as exhibits. The Fleischer versus George case relied on by Serpentini does not hold that public inspection cases must be admitted into evidence, but is simply a dispute about the record. One party argued in Fleischer that the cases were not admitted into the evidence. The other party said, yes, they were. There was no discussion or holding in Fleischer versus George that the public inspection files and certifications must be admitted as exhibits. So that does not support the proposition. So Serpentini claims it had no way to respond to the public inspection files because of simultaneous briefing. Under ORC 2315.01, the court has discretion to change the order of argument, and indeed, Burgett requested a reply brief, which was granted. When Serpentini received the closing brief with the public inspection cases, if they had an issue with that, Serpentini could have requested a surreply or simply filed an objection. Serpentini attempts to circumvent its failure to object by recasting the argument as based on sufficiency. So if the evidence was insufficient, they needed to make a motion to dismiss under Rule 41 at the close of the evidence. They were aware that we were going to make a claim for treble damages. They were on notice because there was a claim for treble damages in the prayer for relief in the complaint. Serpentini could have filed a motion to strike after plaintiff filed the closing brief. Serpentini presents no authority for why the rule requiring preservation of issues for appeal will be any different for sufficiency of the evidence at a civil bench trial.
Did they argue at the trial court level at any point that you failed to present this information to the court prior to the court making the decision?
No. No, they did not. So this issue has been waived. Now, the objection to the fees. So Serpentini is correct. After reviewing the appellant's brief, I believe Serpentini is correct that Rule 16 does not provide a remedy to the court's premature ruling. But that does not change the fact that they still needed to preserve that issue, and they did not. The motion for attorney's fees was evidentiary. It was supported by multiple affidavits and other evidentiary exhibits. They had an obligation to preserve the record. So an offer of proof can be made after a trial. A proffer is not to change a court's decision because the court has already ruled, but it's to make a record for appeal. They did not preserve their objections.
If they didn't have an opportunity on the motion of attorney's fees, the court didn't wait for their filing to say whatever they were to say about their motion.
Well, they could have filed before the appeal. They could have filed their objections to get it on the record. To preserve.
So after the decision of the trial court on attorney's fees, you're saying they could have filed something in the trial court to say, we object, trial court, you made this decision without our input or us filing anything?
They could have made a proffer. They should have made a proffer to get their evidence on the record. If a witness is excluded at trial, you still make a proffer, even if it's after the trial, even if it doesn't change the outcome in that proceeding at that level, you still make the offer. And they didn't, and they should have. So they
Also argued in the brief, they should have filed a 60B motion. At that point, as I recall, do you cite any authority that a 60B motion is the appropriate thing to do in these circumstances? The trial court will not have a chance to respond.
I think I may have, but I think I was probably incorrect, and I do agree with counsel that 60B would not have changed the outcome. But again, just because 60B can't change the outcome, because it was a final appeal of order, I agree. I don't think it would have changed the outcome at that level, but they still had an obligation to preserve the record for this court, and they did not. So their failure to make a proffer or to make any sort of objection on the record at all was a waiver. So turning to the Magnuson-Moss Warranty Act. So the Magnuson-Moss Warranty Act provides for enforcement of state breach of warranty laws, but does not modify implied warranties existing under state law under Curl versus Volkswagen. So Magnuson-Moss provides under 2310E that no action can be brought for failure to comply with an obligation under written or implied warranty. Implied warranty is what we're really talking about here. Unless the warrantor is afforded a reasonable opportunity to cure such failure to comply. The issue is, does reasonable opportunity to cure mean the same as reasonable number of repair attempts? It does not. So the Act does not define cure. The only place in the Act discussing reasonable number of repair attempts is Section 2304, and 2304 is inapplicable because it only applies to full warranties, and we do not have a full warranty here. So
your client sent a letter saying you want rescission of a contract because there are structural problems with the car, and how much time went by without a response?
5 months. And so reasonable number of repair attempts is a part of warranty law, but only express written warranties, not implied warranties. So, and it's not a part of Magnuson-Moss Warranty Act or the Ohio UCC state warranty law. That language comes from, there's many repair or replace warranties. Your new car will repair or replace if there's a problem. Repair or replace a part if there's a problem. And it also comes from lemon laws. Both your warranty with your new car and the lemon laws are about express warranties. So there's no basis under Magnuson-Moss or the lemon laws to apply the reasonable number of repair attempts language to implied warranties.
I entertain the argument in part to be because you didn't ask to have the vehicle repaired in your letter, you only asked for rescission, then they didn't have an opportunity to repair at that point in time based upon your letter.
That is their argument, but under, and I believe I mentioned this under, yes, under RC 1302.65, we're only required to make a notification to the seller within a reasonable amount of time after discovering the defect. But we do not have to specify, we do not have to have specific language about the opportunity to cure. We don't even have to say we want an opportunity to cure, even though that's what we did. So under the under state breach of warranty law and the UCC, as enacted here in Ohio, opportunity to cure includes a chance to negotiate with the warrantor, which is what we did. They had an opportunity to come, the opportunity to cure was to come to us, and also under RC 1302.52, titled Cure by Seller of Improper Tender or Delivery, which is what happened here. The text recognizes substitution with a conforming tender or replacement as a cure, and the comments recognize refund as a cure. So our demand for rescission was a request for cure. But it would have been even if we did not specify what remedy we were seeking. Just it is to put them on notice so that they can take some action if they want to. And I would also point to the Anderson case that was cited in Anderson versus Gulfstream Coach, which was cited in the brief of the appellant. So the Anderson case found that opportunity was provided when a notice was sent to the manufacturer, and the manufacturer even said, oh yeah, we'll fix. But they never did after 2 months. The court indicated the buyer does not have to wait indefinitely for the seller to cure. That was 2 months. Here, this was 5 months after we sent the letter. We did not file suit until 5 months after we sent the letter. So, so there is no requirement under the Magnuson-Moss Warranty Act for reasonable number of repair attempts that applies to the implied warranties. So the Abele case does not represent Ohio law. It alters the language of 2310E from opportunity to cure to opportunity to cure such failure to comply to opportunity to cure the defects without any rationale or citation for doing so. The Abele court only relied on 2304, which again I said earlier does not apply because it only applies to full warranties. And it relied on 2310D, but 2310D does not have language regarding number of repair attempts. So the court grafted this and grafted this reasonable number of repair attempts language onto Ohio law, claiming that it was based on, that if you have a claim for breach of warranty, without restriction as to implied or express written, under either Ohio law or the Act, the Magnuson-Moss Warranty Act, that there must be a reasonable number of repair attempts. But that is incorrect, because the law, as I went through in the brief, Ohio law does not make that requirement for implied warranty. And we just went through the Magnuson-Moss warranty jacket. It's not there either. Now, there were a couple cases that I did not address in my brief that appellants mentioned. So I talked about the Anderson versus Gulfstream Coach case. That does not support Serpentini's position here. The Brown versus Cincy Autos case relies on Temple versus Fleetwood Enterprises. Temple wholly relies on the valet, and in fact, those are often cited together, and does not mention implied warranty. The Syracuse versus, forgive my pronunciation, Syracuse Carapanos versus Ford Motor Company case required reasonable number of attempts to fix the defect to establish a breach of warranty, again without distinguishing implied and express. But for that language, it relied on Witt versus Mazda Motor and Sharkus versus Daimler Chrysler. Witt stated at paragraph 24 and Sharkus stated at paragraph 11, they both stated in order to establish a breach of written warranty under Magnuson-Moss Warranty Act. So Syracuse took the holdings of Witt and Sharkus that only applied to written warranties and basically did the same thing Abelli did, drafted that, overexpanded that to implied warranties, to all.
I'd like to turn you to a couple points in the last bit of time here that the appellant raised. One, at least, is this point that they did not warrant, they only reported they had repair mechanical issues and not the frame. What is your comment about that?
So that is with regard to the express warranty, the Q certification. But they also said that they thoroughly inspected the vehicle, and indeed you can see that language on page 2 of Exhibit 2 from the trial, that the vehicle was thoroughly inspected, and Mr. Burgett said multiple times in the trial on the record that meant to him, and the way that they represented it to him, was that the vehicle was thoroughly gone over. And if you look at page 2 of Exhibit 2, there is no restriction to the body. In fact, there's nothing on there about the body. It's just this vehicle has been carefully and thoroughly inspected and certified. So,
and that's what I take it you're alleging the fraud is in this case, that they claim they had made an inspection and they did not make an inspection.
That is correct. And as to the damages, there was a comment about no evidence of damages for the front camera. Well, Mr. Burgett testified at trial, page 55, that it would cost $6,500 to replace, and it is not repaired. Just because it wasn't from our expert, doesn't mean that's not.
So there was testimony that the camera had been attempted to been repaired, but they did not repair the camera and was not functioning at the time of trial.
Right, and he did not go back because they said, you'll have to pay us $6,500 to fix that. And the buyer's guide, that is on every single vehicle.
You're out of time, so you have to wrap up in about 10 seconds.
Okay, thank you, Your Honors.
Thank you. You'll have a little over 3 minutes for your rebuttal.
Thank you. All right, I just have a few points I'd like to address. First, with respect to the MMWA, Appley goes on at length about how she disagrees with essentially Ohio law and how Ohio law is developed. But under federal law, the MMWA states an action may not be brought unless the warrantor is afforded a reasonable opportunity to cure. That language is mandatory. We cite cases at page 4 of our reply brief. There isn't any distinction in Ohio law between implied and express warranty. I understand that Appley wants to change the law, but this court's bound to follow the law as it's written. And again, this was never presented as a warranty claim. The letter just doesn't constitute a claim for breach of warranty. It didn't ask for it to be repaired, so that's insufficient. It's unreasonable for that to be considered an opportunity to cure. there was no opportunity to cure that was provided. Second, with respect to treble damages, we cite a lot of case law in our briefs. Evidence means evidence. There has to be evidence of these decisions in the public inspection file. That just did not happen. There was not an opportunity to object to that. There were written closing statements that were filed just as if in the normal course they would have happened at trial orally. So there was, they were actually simultaneously, but the appellee only got a chance to respond because she bore the burden of proof. She got that additional rebuttal, but there was no other opportunity to object. They don't cite any case law that you have to file, make a motion in order to preserve a sufficiency claim, so that is invalid. Finally, with respect to the final appealable order and the allegation that we should have somehow challenged the attorney fee judgment, I mean, that was a final order. The remedies appeal, 60B is not the appropriate mechanism. And then finally, a lot of these claims turn on knowledge. And the trial court expressly found that Serpentini did not know of this damage. And that destroys a number of the claims, including the CSPA claim, and certainly the attorney fee claim, because that requires knowing conduct. So if there's no more questions, I will conclude. Thank you.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also our opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations.